Welcome to another edition of Inside Rosenberg and Estis. Today, if you're a landlord, you've got to watch this episode of our show. We are talking about a way that you could potentially solve one of the biggest problems that's keeping you up at night. That's when you have someone in one of your properties who's refusing to pay and refusing to leave. Our expert today will help you understand the steps you need to take to make sure you get what you're due from that situation. I'd like to welcome in Alex Estis to talk about how we can make sure that our interests are protected when a tenant doesn't want to pay and they choose to stay. Alex, welcome to the show. Thanks for joining us today.
Thanks for having me, Dave. Good to see you again.
It's great to see you. So, Alex, I just saw the Law Journal article that was published. In fact, as we're doing this interview, the Law Journal article came out today. Why did you write this Law Journal article on use and occupancy?
The reason I co-authored this article with Gary Rosenberg was because it's not a big revelation that if you're a landlord in a landlord-tenant dispute, you want to ask for use and occupancy. Obviously, you want to get paid rent as the case is going on. What's not done in today's practice that I see is that landlords ask for it on an emergency basis. And there's a specific way to ask for it where you can get it immediately. You can get it at the beginning of the case. And that potentially could expedite your results in the case and make things move a little bit quicker. The problem I see is that most landlord attorneys will ask for use and occupancy the same way, which could take months and months to process. It's not just about knowing what to ask for. It's knowing how to ask for it in the right way, which is why I wrote this article, because it's something that I don't think enough people in the industry are doing.
All right, let's get into it. I have a couple of questions about this, and I want to dig into this topic in a little detail with you. Let's talk about the thing that keeps the landlords that you and I know awake at night. They got somebody in one of their units, and for whatever reason, they're no longer a productive tenant. They've decided that they're not going to pay. Now, we know the law is on our side, but getting the money from them is one of the things that is absolutely the bane of our existence if we're a developer, if we're a property owner. Now, you just wrote a Law Journal article, just came out, hot off the press. Tell us what we can do to protect our interests when this happens.
Well, Dave, first, let me clarify that New York State has protections for both landlords and tenants. And there are procedures in place to make sure that tenants are protected from overcharge claims and not being harassed and being treated unfairly by the landlords. But the juxtaposition of that, Dave, is that there's a remedy called use and occupancy that a landlord can seek in court, that while a dispute is pending, because again, during a dispute, when you have a dispute, it's the landlord has one claim, the tenant has one claim. Someone's going to be correct. But during the pendency of that litigation, the litigation could last months or even years, as some people could see. The landlord's entitled to get use and occupancy from that tenant while the case is going on. The tenant might be withholding rent because they feel that they don't have to pay, the landlord's not doing something, or perhaps they just don't have the money, and that could be part of it. But the landlord is entitled to due process, and the status quo should be maintained while the litigation is ongoing. That's why landlords can seek what's called use and occupancy during the pendency of the litigation.
All right, so the tenant, everything is going well, the tenant is paying their rent, things are going fine, and then something happens. And, for our purposes, for the purposes of this discussion, it doesn't really matter what happened. Either the tenant decided that they weren't going to pay for a reason that they believe to be valid, or something happened to the tenant and they just can't pay right now, so they're not paying. And the landlord decides they're going to initiate some sort of action to either evict the tenant or get the tenant to start paying again. What you're saying is, while that action is going on, the status quo, what was already happening, needs to continue. So the tenant was paying and then they stop paying. The landlord initiates the action. During the action, the status quo prevails. They have to continue to pay. And then what's the ultimate decision at the end if the landlord is found to be correct, be in the right? Then the payments that were made, are they made to the court during that time, or are they made directly to the landlord? How does that part of it work?
So, Dave, two very important things. To answer the second part of what you just said, the appellate division, in a case in which I represented the landlord of the Gap in Old Navy in Times Square, tackled that very issue. When interim use and occupancy is ordered, the payments are to be made to the landlord and not deposited with the court. In that case, Supreme Court had said that the money should be paid into court each month, and the appellate division said no, it needs to go to the landlord directly. Now, to address the first part of your claim, the action you take actually really depends, and it matters very importantly. Some people will go into what's called civil court and commence a summary proceeding against a residential or commercial tenant, and there, a landlord can't obtain use and occupancy unless they comply with a law that's called RPAPL 745. There are certain criteria that the landlord has to meet in order to get use and occupancy there, which is the petition has to be pending for at least 60 days, and there has to be only certain claims raised by the tenant. The checklist has to be made, and that could take some time. What I'm saying is, if you're a landlord and you commence an action in Supreme Court, you can make an application for use and occupancy immediately at the beginning of the case, simultaneously upon commencement, and get an emergency order. And the law says, specifically in Manhattan, it could vary in Brooklyn and other boroughs, but specifically in Manhattan, you are entitled to use and occupancy as a matter of law. In Supreme Court, a landlord can be entitled to use and occupancy at the beginning of the case. I could file a lawsuit on Monday, and I could potentially have an order based on an interim order by virtue of what's called a TRO, temporary restraining order, by Tuesday or Wednesday, saying the tenant has to pay rent within X days and will continue paying each month until a further order of the court. That right there is something that's equitably fair because the status quo needs to be maintained. The law says that a tenant cannot simply stay in an apartment rent-free while the issues are adjudicated. So you're saying a landlord can take action. I'm saying it depends on the action the landlord takes, which is why, if possible, a landlord that wants to get use and occupancy right away should take a look into going Supreme Court first.
Okay, so let's go through step by step what happens. So it's, let's say today is Monday and the rent was due, for argument's sake, the rent was due 4 weeks ago. And the tenant hasn't paid. The second rent is due, and it's the day after the second rent was due on Friday. So now they're a month in arrears, and the second rent is due. The day goes past. Is that when I should call you? What's the day when I pick up the phone and I call you and I go, hey, my tenant is now a month behind on one rent, and they're 24 hours behind on the second rent? Is that the point where I call you? At what point do I get you involved?
I always tell clients on both, when I represent tenants and when I represent landlords, whenever there's an issue, first talk to your landlord or talk to your tenant, see if you can work it out between the two of you. That's always the best thing, and that's what I always try to encourage people to do. If after one conversation, it doesn't seem that it's going to resolve itself, you should call me right away. You should call your attorney, whoever's representing you, right away. And in fact, I would say when something happens, call your attorney first. I would then say to you, try to work it out, but I would try to help advise you on what it is that you should be discussing, what's the best way to approach it, because the best interest for everyone is try to working out your issues amicably.
All right. So actually, that I think that's a really good point, Alex. I call you first because there are probably some things that I should say, and more than likely there's some things I shouldn't say in that conversation, right? So the minute that I suspect something's up, let's say the rent is 3 days late, I call the tenant, and the tenant says whatever they say to me. At that point, if I know the tenant isn't going to pay, whether they give me a put off, a stall, or whether they just say I'm not going to pay, I need 3 or 4 weeks, then I pick up the phone and I call you. At that point, is that when a suit would be brought, or do we wait and see if the tenant makes good on whatever they promised me in that first phone call? Because you and I both know, Alex, let's face it, if I get a hold of the tenant and the tenant doesn't have the money, there's going to be a story. There's always a story. So the story will end with, and I'm going to get you the money on this date. What do I do to protect my interests if this date in that scenario is 2 weeks in the future or a month in the future? I don't want to delay what could be a really bad situation. Isn't it that time that I need to call you after I hear what the story is?
Well, I was saying before, you should call before you even have the conversation. Okay. It really depends on a case-by-case basis, because what matters more than anything is what your contract says. What does your lease say with the tenant? What does your lease say with the landlord? And you have to look at what the factors are in the case in that specific instance. And then it helps me tell you how to have the conversation. It best helps you figure out how to have the conversation and approach it. But let's say, for purposes of your question, we reach the point of no return. It's very clear that this isn't going to resolve itself. The tenant isn't paying rent, or they're not complying with a material obligation of the lease. If we have tried to avail ourselves of all reasonable action, and it seems that's not going anywhere, we would then have to commit a lawsuit and file a complaint for whatever the damages that have been incurred by that party. And to maintain the status quo, it's important for the landlord to try and get an emergency order for use and occupancy, because that way, while you're litigating, everything's balanced. Because while a tenant's staying there not paying rent, the landlord has expenses to maintain the property. If you have a mortgage, you're probably not getting forbearance from your lender. You have your real estate taxes, all the expenses that you incur. And at the same time, you're not getting income, but you have a legal obligation as a landlord to maintain your property in a habitable and safe condition. That doesn't alleviate because the tenant's not paying rent. Now, with that being said, it's also very important for the landlord to do it, because it's not just about getting money coming in. It's about getting expediency and getting fair due process, because the remedy for a landlord, if a tenant doesn't comply with paying use and occupancy and the court orders it, the tenant has to understand that's a court order. You can't simply thumb your nose at a court order in New York. Then you're going to be held in what's called contempt of court, which is the court will sanction you for failing to comply. Now, it's not always automatic that a landlord will be entitled to use and occupancy, because again, the situation can vary. But if the tenant doesn't comply with use and occupancy, the remedy for landlord as part of getting contempt is eviction. You could evict someone immediately within a month or 2 months even, if they don't comply with the use and occupancy order. So that's something that shouldn't be taken lightly. That's something that a landlord should move for use and occupancy to maintain the status quo. And the court has been very clear that the reason they do this is because the condition of staying in the apartment is paying rent and paying use and occupancy. And with a court order, a landlord can get use and occupancy when a tenant is holding over past the expiration of their lease, or if they have a lease in effect, while the lease is in effect, they have to pay rent, and the court will use the term use and occupancy or an interim rent order. The terms are interchangeable for this purpose, to make sure that the status quo is being maintained. And so it's something that landlords should strongly consider. And this is something that is not the simplest motion in the world. It's a little complex, that they should come talk to their trusted Rosenberg and Estis attorney about before commencing the case. All right,
so there's something really important that you just highlighted there. You highlighted the fact that if you get this order for them and then the tenant still doesn't pay, it could expedite the eviction. Am I correct in that?
Yes, it could expedite the eviction, because for that order to occur, saying that the tenant must pay, the court will have had to have made a determination that the tenant is using and occupying its premises. What using and occupying means is that a tenant is in possession of certain property, that they either occupy it, which could be by virtue of their residing there, they're doing business there, or their storage of property. If the tenant is getting a benefit, they are obligated to compensate the property owner, the landlord, the party that put them in possession, for their use of it. This doesn't matter if you're a residential tenant or you're a commercial tenant. It actually doesn't even matter if you're doing business. If you just have property in the space and you have exclusive use to put your property in that space, unless you have told the landlord that you've abandoned it, you will be likely ordered by the court to pay use and occupancy. Now, the use and occupancy will continue for as long as you're in possession. If you vacate before you have to pay, the court will probably find you don't have to pay it. If you don't pay, and those are the factors, the court orders it, the landlord will be entitled to immediate possession. And there have been situations where landlords have had to wait a couple of years to adjudicate the issues, but this could be an expedited remedy for a landlord that's been aggrieved by a tenant.
Okay. I'm going to ask you a couple of questions about this just because I've seen it happen in the past. So you're the landlord and you have a big operation and things happen and the tenant decides that they're going to make a partial payment and somebody from your team unknowingly accepts the partial payment. While you have this order, what happens? Is the order still, can the order still be enforceable if you've accepted a partial payment, even if you did it accidentally?
It would be hard for a tenant to be able to say to the judge, I know you told me to do this, I only did half of what you told me to do. A court order is a court order. You have to follow it to the letter. And so if a tenant has an issue with being able to comply with an order, the prudent thing is for the tenant to talk to their counsel about what remedies or actions they could take, which again vary on a case-by-case scenario.
Okay. Now, is this different with commercial property versus residential property? Because a lot of the people who are joining us today may think to themselves, hey, listen, residential, somebody's living there, I get it, but like commercial property, if I'm operating my store and I decide not to pay, I'm still operating my store, is that different? Or does the law apply equally to commercial and residential?
I'm going to give you a lawyer's favorite answer.
It depends.
Yes and no.
Okay. I thought you were going to say it depends.
Yes
okay.
and no.
Okay. Yes and no. Give me the yes first and then the no.
So the yes is most residential cases are handled in housing court. Housing court is a civil court proceeding, which is a statutory proceeding, and you can't get use and occupancy in civil court without going through what I said before, which is RPAPL 745, which takes at least 60 days, if not more. There's certain factors, and a tenant won't have to pay use and occupancy if they're a stabilized tenant and they're arguing that the rent's been overcharged, and a couple other factors that really depend. In the commercial context, if you're in civil court, it's the exact same thing. You have to comply with 745, can't really get it expeditiously. In Supreme Court, in the residential context, in the commercial context, you can get it. We had a situation where I represented a co-op in the Upper East Side a couple of months ago. There was a superintendent that they hired. The superintendent was fired, and the court found that he was entitled to pay use and occupancy, and the co-op was entitled to collect it because the superintendent was staying in an apartment after he was fired and had to pay the fair market value for as long as he was there. The superintendent ultimately didn't do that, and the court awarded us an award of ejectment, and he was ultimately evicted, and this was within 2 months. We started the case in October, and this individual was evicted in early January, which in today's day and age is a very expeditious way to evict someone, but it's because the case law says that a landlord needs to be compensated while there's a dispute. Now, in the commercial context, it's a lot more frequently used to get a use and occupancy order while you're litigating a dispute. And just because a court gives a use and occupancy order, it doesn't mean the landlord's right or the tenant's right There could even be a dispute as to what the amount of rent is. And the court can order an amount of rent, and they have the discretion to set an amount while it's being paid. And the tenant's remedy, while they comply with the order, is that they could have a speedy trial, because the common law remedy for the overpayment or underpayment of rent is a speedy trial. And if it turns out the tenant's correct, they're going to get credited back. That's what a court is most likely going to say, is that they will be credited back if there was an overpayment. If there was an underpayment, they're going to be ordered to compensate the landlord for the difference. Because at the end of the day, what's supposed to happen is when you go to court, you're supposed to get the fairest result based on what the law says and what the facts are. Whether or not that always happens, I can't say. But that's what the intent is of our judicial system, to follow the laws and do what's fairest for the parties.
So whether it's the commercial scenario or the residential scenario, the step-by-step guide is somebody doesn't pay. You call Alex first. Alex will coach you on how that conversation should go. You have the conversation. If you're the landlord, you have the conversation with your tenant. If the conversation is not satisfactory to you as the landlord, you call Alex back. Alex will determine what to do in that case. If you reached the point of no return, then when Alex files the suit, he will file in, I want to make sure I get this right, Alex, you'll file in Supreme Court so that you can get use and occupancy, which is only designed to maintain the status quo. It's just designed to do what's fair. It's not designed to get a final result. That's what the case is for. But while the case is progressing, just maintaining the status quo is what you're trying to accomplish with this process. How did I do, Alex? Did I get it right, the whole thing from beginning to end there?
You're pretty close, Dave. What I can say is, if there's a dispute with rent, call me, call any of your trusted Rosenberg and Estis attorneys, and we will tell you what situation we think is most appropriate for you, whether that's going to Supreme Court, whether that's going to civil court, and we can specifically discuss getting an interim order for use and occupancy. Ask us that question, and we'll tell you if that works for you. If you're a tenant and you're facing that situation, call us anyway, and we can figure out how to best represent you in that capacity. But at the end of the day, it depends on the specific lease, the specific facts. No landlord should think that this remedy that we're discussing is a one-all. This is what you do in every situation. It's not something that can always be fixed by yourself. It's about what counsel you have and getting advised in the process to make sure that you're taking advantage of the right steps. And making sure that once you go through the right steps, you take the right action. Just going to court is not enough action in and of itself. It's the action that you take within the action that matters most.
And that's the reason for reaching out to an attorney who does this all day, every day like you do, Alex. So how can folks get a hold of you if they want to discuss this or any other real estate related matter here in New York with you? What's the best way for them to reach out to you?
You can call me in my office at 212-551-1204, or feel free to email me at aestis@rosenbergandestis.com.
All right, folks, you heard it here from Alex Estis. This is something that you may not have known about, and candidly, it's something that a lot of people don't realize they have the right to ask for. If you want to dig more into this, reach out to Alex at Rosenberg and Estis. His contact information is down in the show notes. This has been Inside Rosenberg and Estis. My name is Dave Lorenzo. Until next time, we are here to answer all your real estate related questions, whether it's commercial or residential. Thanks for joining us today. We'll see you again right here on Inside R&E.